Oh, hey guys. Okay, so I'm a bit on the back foot with this one. I do need to catch up with it. So, um, my last video was Maren Flagg had amended her complaint. Taylor Swift filed a motion to dismiss, which I'm going to go through briefly now because it's quite a long memorandum, nearly 40 pages, but also like there are a bunch of attachments. So I'm not going to go through all that because a lot of it is very similar arguments to the first motion to dismiss. Then my next video will be an order because we have an order on the original motion to dismiss, which is obviously going to be denied as moot. But there was also a pending motion for preliminary injunction. So there's a bit on that, and I'll do that in the next video. For anyone who is interested, I will be keeping up with my celebrity lawsuits. But I will also be following the murder trial for, Anne Widdecombe. So Anne Widdecombe, obviously, from the UK. Even if you're not, you might well know her. She spent, many years as a politician. At 78 years old, she was a kind of a spokesperson for Nigel Farage's Reform Party. And she was absolutely brutally murdered in her own home while sat just eating a lunch by some complete lunatic. I will be covering that trial as well because the facts of that are just absolutely horrific. And I'll be doing a bit more UK stuff now. We've got a new unelected prime minister and a few things going on. Anyway, so yeah, I'm coming straight in at the argument stage because we already know the legal standard. We already know the factual background. So I'm not going to kind of waste time going over all of that again. So I'll just come straight in here. Okay. So the amended complaint should be dismissed pursuant to Rule 12b-6. Despite amendment, plaintiff still fails to state a claim upon which relief can be granted. The entire amended complaint should be dismissed with prejudice. So Swift is making the same arguments that Maren Flagg's claims are barred by First Amendment. Her work was an expressive title, etc., which I find hilarious because, it only become, oh, well, it's just an expressive title after she attempted to trademark it herself, and was told, sorry, you can't. There is already a trademark for a very similar, work, basically. But yeah, now it's an expressive work. What are you talking about? I can do this. Rules for the. So, notwithstanding plaintiffs' attempts to characterize the album as a brand, the reality is that it's a musical album. It's an expressive work titled The Life of a Showgirl and is protected by the First Amendment. This protection extends to associated merchandise. Plaintiffs' claims therefore fail as a matter of law. Where the allegedly infringing use of a trademark is in the title of an expressive work, courts apply the Rogers and Grimaldi test. Under Rogers, a plaintiff cannot state a claim unless she plausibly alleges the challenged title 1 has no artistic relevance to the underlying work, or 2 explicitly misleads consumers as to the work's source or content. Failure to plead either prong warrants dismissal. Songs and album titles are the core expressive works Rogers protects. Plaintiff does not and cannot allege that the album title lacks artistic relevance to the underlying work, nor does she plausibly allege the title explicitly misleads or misleads at all as to source. To the contrary, the album prominently displays Miss Swift's name and likeness, making its origin unmistakable. Indeed, plaintiff admits that the use of the Taylor Swift name and brand is pervasive in connection with the album and promotional merchandise. A closely analogous decision confirms dismissal is warranted. In Down to Earth Organics against Efron, a plaintiff sought to preclude Netflix and its lead actor, Zac Efron, from using Down to Earth in a television series title and related promotional activities. The court applied Rogers, found the series was expressive, and dismissed the complaint. Critically, the court held that promotional activities, including cross-promotion of snack bars, were protected under Rogers, even though revenue generating. The same reasoning applies here. Plaintiff's attempt to avoid Rogers by recharacterizing the life of a showgirl as a source identifier fails. Labeling an expressive work's title as source identifying does not make it so. Indeed, Lost squarely rejected this argument, denying injunctive relief applying Rogers to an album title and merchandise post Jack Daniels, despite the plaintiff's claim that the title was a source identifier. Notably, plaintiff provides no images showing how the album or promotional goods appeared to consumers, which would reveal the Taylor Swift and Republic Records trademarks prominently denoting source. Regardless, plaintiff admits that the Taylor Swift brand is consistently and pervasively identified on both the album and promotional merchandise. Indeed, the web store and storefront masthead are branded exclusively with Taylor Swift, and plaintiff herself calls it the Taylor Swift online store. Plaintiff also explicitly calls out the tags and labels attached to promotional merchandise which identify the source of the products, but conveniently omits that all such labels prominently feature Taylor Swift alongside the album title. Courts reject trademark claims where defendants' branding makes the true source unmistakable. That is clearly the case here, because plaintiff has not plausibly alleged either Rogers' prong that the life of a showgirl lacks artistic relevance or explicitly misleads as to source, the Lanham Act does not apply, and the album and its promotional materials are protected under the First Amendment. Dismissal with prejudice is required. Plaintiff still fails to plausibly allege likelihood of confusion. Now, I don't agree with this. I think this is disingenuous because she did actually cite several examples where people got confused. Very similar to, like Deadpool and Wolverine hiring a dancer to perform an iconic dance that even if you turned the music off, you could, there are generations of people who could identify where that dance came from because it was so tied together, it was so iconic, and it was so unique. And then, because it's used in the Deadpool and Wolverine film, the choreographer, Darren Henson, kind of gets lost in translation, and, it becomes known as the Deadpool dance. It is not the Deadpool dance. It was around for 25 years before Deadpool. It has its own history, which overnight it was just erased. And that is essentially the same argument that Maren Flagg is saying here is, look, if Taylor Swift, kind of takes hold of this, my trademark will become worthless. I will lose my brand because people will associate this, as they already are in all these examples, as something that is from Taylor Swift. And I think she made the argument very, very well. Even if Rogers does not bar plaintiff's claims, it does. She again fails to plausibly allege likelihood of confusion, an essential element of her claims. Plaintiff must allege facts showing that reasonably prudent consumers are likely to be confused as to the source, sponsorship, or affiliation of the goods and services at issue. For reverse confusion, plaintiff must also show consumers would believe defendants are the source of plaintiff's services. Here, that Miss Swift is the source of a live cabaret performance at a small venue. If the court determines as a matter of law from the pleadings that goods are unrelated and confusion is unlikely, the complaint should be dismissed. Among other bases, courts dismiss where 1. Marks are obviously dissimilar, 2. Products target different purchasers, marketing channels, or 3. Goods or services are unrelated. All 3 bases apply and warrant dismissal. Plaintiff's mark is conceptually weak. Plaintiff concedes that her alleged mark is conceptually weak, and with good reason. It is comprised of a common dictionary terms describing her cabaret show. Oh, now they're just common dictionary terms. This is from the same woman who trademarked a year. This weakness, combined with widespread third-party use of confessions of a showgirl and of a showgirl in the entertainment industry, negates any likelihood of confusion. Plaintiff's alleged goods and services are dissimilar to the album and its promotional goods. Plaintiff's amended pleading also fails to cure this defect. In connection with the life of a showgirl, plaintiff alleges defendants released a musical album and promotional merchandise, including brushes, towels, rings, candles, tumblers, personal care, and home goods. In contrast, plaintiff allegedly offers a live cabaret show, book, podcast, and video content. She does not allege she sold any products, much less those attributed to defendants, or released musical albums or performed concerts. Plaintiff unsuccessfully attempts to plead around this glaring lack of overlap by alleging both parties' offerings center on live musical performance and that all consumer-facing entertainment products are related in consumers' minds. Plaintiff's conclusory assertions are ludicrous and unsupported. Plaintiff is a comedian and cabaret performer that has never released any music. In contrast, Miss Swift has never offered a cabaret show, comedic or otherwise, or any live performance in connection with the album. Labeling distinct services as entertainment does not mean they are similar to consumers. Even taking plaintiff's allegations as true, they are not. Plaintiff has not alleged anything more than legal conclusions regarding the purported minds of consumers. The alleged channels of trade are dissimilar. Plaintiff's channels, performances at the Laurie Beechman Theatre and Myron's at the Smith Center, a Las Vegas weekly column, and her website and social media bear no resemblance to defendants' channels. She fails to allege when these activities occurred or that defendants marketed the album through those venues or publications. Defendants' only alleged channels are retail channels and the Taylor Swift online store, making it unmistakably clear who defendants' album and associated goods are affiliated with. Plaintiff's conclusory assertion that these channels target the same audience lacks factual support. She provides no information about her audience or why it would overlap with Miss Swift's. Plaintiff's mark and the album are dissimilar to consumers. Plaintiff claims the similarity between Confessions of a Showgirl and The Life of a Showgirl is immediate, and that they share a dominant phrase and commercial impression. Not so. And these are conclusory assertions unsupported by facts about how consumers encounter the phrases in the marketplace. Tellingly, despite defendants identifying this glaring omission in their prior motion to dismiss, plaintiff still omits photographs or descriptions of how her mark or the album appeared to consumers. Courts have dismissed trademark infringement claims with far more information than plaintiff provides. When viewing plaintiff's marks, the album and its promotional goods as they appear in the marketplace, they are clearly dissimilar, differing in dominant terms, meaning, font, coloration, spacing, and overall commercial impression, examples of which are depicted below. Personally, I do think Marine Wade's look better, more colourful. They pop more. They just draw you in more. I've never liked the album cover, Taylor Swift's album cover for Life of a Showgirl. I'm sorry, she just looks like she's wrapped in cling film and in a bath full of water. It, it I don't know. It's just in dirty water at that. um, I just don't like it. It doesn't. It never has engaged me at all. Plaintiff's allegations regarding actual confusion are conclusory. Plaintiff asserts without any evidence that multiple instances of actual consumer confusion have been documented across public platforms. Such vague allegations are insufficient. Nor does plaintiff adequately plead reverse confusion, although she alleges defendant's scale may overwhelm her brand. Even after being put on notice of this issue by defendants, she is not able to allege facts showing that an appreciable number of, or any, consumers believe defendants are the source of plaintiff's cabaret performances or vice versa. Yeah, I don't agree with that. I think she did actually make a reasonable showing. Plaintiff's reliance on the USPTO's purported refusal to register the intent to use application also fails. The USPTO's preliminary office action is non-final and raised no objection to 12 proposed classes of goods. Dressing up a non-final office action involving an intent to use application as proof of confusion underscores plaintiff's lack of plausible facts. In sum, plaintiff's allegations simply amount to formulaic recitations of the elements of trademark infringement, insufficient to sustain the claim and requiring dismissal. Plaintiff's new secondary liability allegations are insufficient. Plaintiff's direct infringement claims fail under Rogers and for lack of likelihood of confusion. Absent direct infringement, plaintiff's secondary liability claims must also be dismissed. But even if plaintiff's direct infringement allegations survive, they should not, her formulaic recitation of vicarious and contributory liability elements is insufficient to sustain her secondary liability claims. Vicarious trademark infringement requires facts showing the defendant and the infringer have an apparent or actual partnership, have authority to bind one another in transactions with third parties, or exercise joint ownership or control over the infringing product. Without such control, vicarious liability cannot exist. Contributory trademark infringement requires facts showing the defendant 1. Intentionally induced the primary infringer to infringe, or 2. Continue to supply an infringing product to an infringer with knowledge that the infringer is mislabeling the particular product supplied. Conclusory allegations amounting to formulaic recitation of the elements must be dismissed. Dismissal is warranted where defendants are lumped together without differentiating direct from secondary conduct. Plaintiff's amended complaint contains only 2 nearly identical photographs referencing vicarious and contributory liability. Formulaic recitations without facts showing how any defendant intentionally induced another, supplied products it knew to be infringing, or had any authority to bind or control co-defendants. Do you know, I think if I have to if I have to say formulaic recitation, then we should consider drinking games at this point. Nor does plaintiff explain how defendants can be liable for both direct and secondary infringement for the same conduct. Dismissal is required. Plaintiff's UCL claim still fails as a matter of law. Plaintiff's amended allegations still fail under California's unfair competition law. The UCL requires an unlawful, unfair, or fraudulent business act or practice causing injury in fact and lost money or property. Plaintiff alleges only unlawful and unfair conduct. Neither theory alleges facts sufficient to survive dismissal. Plaintiff fails to allege conduct by each defendant in California sufficient to state a UCL claim. Courts reject UCL claims where misconduct or injury occurs outside California or the challenged conduct is not tied to the state. Plaintiff fails to allege facts showing relevant conduct emanated from or caused injury in California. At most, she alleges certain defendants conduct business in California and that products may reach consumers there, among other places. That is woefully insufficient. First, plaintiff is a Nevada resident who does not allege she ever performed or sold goods in California. Her alleged time previously living in California of unknown duration and unspecified industry relationships there are irrelevant and, at best, conclusory. Second, plaintiff does not allege facts showing the relevant conduct was conceived, reviewed, approved, or controlled in California by each defendant. Her allegations that defendants engaged in California-based sales or participated in unspecified coordinated activities purportedly directed and controlled in part by California-based entities, UMG and Bravado, are entirely conclusory, largely inaccurate, and fail to identify where the alleged misconduct actually emanated from. That UMG and Bravado are headquartered in California does not change this. Plaintiff alleges UMG released the album from its California operations, but admits Republic Records is UMG's division that serves as Swift's record label. Republic Records is based in New York. Likewise, although Bravado is incorporated in California, plaintiff provides no facts to support her assumption that goods were sold from California to consumers in California. Plaintiff's UCL claim is even weaker as to Ms. Swift and TASRM. TASRM is a Tennessee company that does business from Tennessee and has no specific connection, alleged or otherwise, to California, let alone to the complained of conduct. All TASRM work, including IP ownership, licensing, and commercialization, is directed from Tennessee. Ms. Swift is domiciled in Tennessee, and plaintiff provides no nexus between Ms. Swift allegedly owning a California property and plaintiff's UCL claim. Plaintiff's allegations as to Ms. Swift, even if true, do not establish that any relevant album decisions occurred in California. Billboards and fan activities promoting the album and expressive work were available throughout the United States, and plaintiff does not identify a single relevant promotional appearance in California because there was none. Moreover, plaintiff provides no facts showing Ms. Swift or TASRM have California-based affiliates or are affiliates of UMG or Bravado. Affiliate is a term with specific legal meaning relating to common entity ownership. Even if such affiliation was alleged, it is not. It would not establish California emanating conduct absent specific forum-directed acts. Plaintiff's UCL claim should be dismissed on this ground alone. Plaintiff's unfair allegations fail as a matter of law. Plaintiff re-alleges that defendant's conduct is unfair within the meaning of the UCL, but again pleads no facts to sustain her claim. An unfair UCL claim requires conduct tantamount to a violation of an antitrust law, threatening or harming competition in the market. Unfair claims predicated on trademark infringement typically fail to meet this standard. Plaintiff does not plead facts supporting an antitrust violation. She merely alleges without support that defendant's conduct violates the policy and spirit of the state and federal trademark law. She recasts her Lanham Act claims as something they are not, with buzzwords about market power and harms to competition without factual support. This is precisely the type of ambiguous allegations California courts find insufficient. Plaintiff's alleged injuries, impairment of brand control, diminished mark value, loss of source identifying function, and displacement in digital channels, even if supported, they are not, describe trademark harm to plaintiff as an individual, not antitrust harm to competition required by the UCL. Her vague references to prospective California performance engagements and an unnamed production company fare no better. Having failed to overcome the UCL's extraterritoriality bar or to adequately allege unfair conduct, plaintiff's UCL must be dismissed. The court lacks personal jurisdiction over Ms. Swift and TASRM. The amended complaint still fails to establish personal jurisdiction over Ms. Swift and TASRM. Personal jurisdiction over non-resident defendants like Ms. Swift and TASRM requires minimum contacts with the relevant forum, such that maintenance of the suit does not offend traditional notions of fair play and substantial justice. Each defendant's alleged conduct and connections must be such that the defendant should reasonably anticipate being hailed into court here. California's long-arm statute extends jurisdiction to the limits of due process. Personal jurisdiction exists in two forms: general, based on continuous presence in California regardless of where the cause of action arose, and specific, contacts related to the claims at issue. Plaintiff fails to establish either as to Ms. Swift or TASRM, requiring dismissal. There is no general jurisdiction over Ms. Swift or TASRM. Ms. Swift and TASRM are not subject to general jurisdiction in California. For entities like TASRM, general jurisdiction requires continuous and systematic contacts, in almost all instances, the place of incorporation and principal place of business. For individuals like Ms. Swift, the Paradigm Forum is domicile, not merely where one owns property, but one's permanent home. Plaintiff does not allege and cannot establish general jurisdiction over Ms. Swift or TASRM. Ms. Swift allegedly maintains a residence in California, but she is domiciled in Tennessee. Property ownership does not equate to domicile. All other alleged California contacts, plaintiff asserts, are irrelevant to general jurisdiction over Ms. Swift. For example, her involvement in Toy Story 5, or that she attended an awards show in the state. TASRM is undisputedly a Tennessee company with its principal place of business there. Licensing with California entities, even if true, does not remotely render TASRM essentially at home in California. By plaintiff's logic, TASRM could be held into court wherever any licensee has an office, an insufficient nexus for general jurisdiction over Ms. Swift or TASRM. Specific jurisdiction over Ms. Swift and TASRM is also lacking. Because general jurisdiction is absent, plaintiff must establish specific jurisdiction over Ms. Swift and TASRM. She has yet again failed to do so. To exercise specific jurisdiction, plaintiff must allege facts supporting 1. Ms. Swift and TASRM purposefully directed activities at California. 2. Plaintiff's claims arise out of or relate to Ms. Swift and TASRM's forum-related activities. And 3. The exercise of jurisdiction is reasonable and fair. Plaintiff bears the burden on the first two prongs. If either fails, specific jurisdiction is absent. Here, plaintiff still fails to allege facts supporting any of the three requirements. No purposeful direction towards California exists. For tort-based claims like Lanham Act and UCL claims, courts apply the Calder effects test. Plaintiffs must show Ms. Swift and TASRM 1. Committed an intentional act, 2. Expressly aimed at California, and 3. Causing harm they knew would likely be suffered there. Courts declined to find express aiming where specific defendants did not personally sell allegedly infringing products or products were generally available to the public. Plaintiff has not satisfied Calder. She cannot establish jurisdiction by pointing to unrelated activities like Ms. Swift's Toy Story 5 involvement or by aggregating UMG's, Bravado's, or other third parties' California contacts. Personal jurisdiction must be assessed as to each defendant. Plaintiff does not allege Miss Swift personally sold, distributed, or placed billboards related to the album or promotional materials in California, or that any such placement targeted California more than any other state. Album promotional merchandise was not photographed in California. Miss Swift's alleged invite for fans to attend a release party film was filmed in Tennessee, distributed globally online, and did not include a single mention of California. And while plaintiff alleges Miss Swift wrote and directed a music video and appeared at an award show in California, those actions, some of which did not even occur in California, are unrelated to plaintiff's claims. First, neither the creation of a music video under the First Amendment nor receiving an award is a commercial activity. Even if deemed promotion, it is not. The alleged conduct is fortuitous and not purposeful availment sufficient to sustain jurisdiction. Plaintiff alleges no facts that Miss Swift controlled where the iHeart Music Awards were presented or the music video was filmed, negating purposeful availment. Plaintiff's remaining allegations rely on the existence of a theoretical license agreement, which is insufficient. Even if such a relationship existed, the mere existence of a licensor-licensee relationship without more is insufficient to impute the contacts of a licensee on the licensor for the purpose of establishing personal jurisdiction. Plaintiff's allegations that Miss Swift selected and adopted the album title and authorized and licensed California entities to use it, even if true, are insufficient to show California-directed conduct or requisite control over UMG or bravado. Plaintiff's TASRM allegations fail for the same reasons, even if TASRM owns, administers, and enforces intellectual property rights behind the life of a showgirl and exercises active control over licensing with UMG and bravado. That does not show California-directed conduct. Trademark quality control is expected of any trademark holder, particularly here, where plaintiff alleges the Taylor Swift trademark is on the album and promotional materials. It is not enough to merely allege control generally. Further, nothing in plaintiff's pleadings supports that TASRM expressly aimed conduct at California as opposed to other states. As detailed, TASRM does not manage Miss Swift's commercial appearances, and all operations occur in Tennessee. Plaintiff's allegations about selling the album and merchandise through an online store accessible in California are also insufficient. Making goods broadly available online without specific California-directed advertising does not support jurisdiction. Plaintiff's allegations, even if true, do not demonstrate that Miss Swift or TASRM's purported contacts with California did not merely arise from California consumers' choice to purchase goods from defendants, making them insufficient to confer personal jurisdiction. I mean, I have to agree with some of all of that. I do. I want to see how Maren Flagg does respond, but the jurisdictional arguments are pretty good. They're pretty strong. I mean, at least they're not as bad as Blake Lively trying to say, well, you knew I was a New York girl because I posted on social media. And, well, they were texting and the time zone was Eastern, so clearly, New York law applies to Jed Wallace. They were wild. They were wild. The arguments here are more rational. That's why I'm a bit like, I feel more 60-40 in Taylor Swift's favour, just on jurisdictional arguments, though. But we will see the response. And again, that's purely to Taylor Swift and TASRM. That does not apply to UMG and Bravado. They are California-based entities, but they make a fair argument about Republic Records and the fact that that is based in New York, and Republic Records are actually the arm of UMG that deals with the actual record label for Taylor Swift. Maren Flagg is going to have to, pull something out to argue back. I look forward to reading that. Okay, let's continue. Finally, nothing supports that Miss Swift or TASRM were aware of any California harm or that any exists. Plaintiff is a Nevada resident, does not allege she performed or sold goods in California, and her purported California industry relationships and prospective business are vague and unspecified. Plaintiff has failed to satisfy the purposeful direction prong, which alone defeats jurisdiction over Miss Swift and TASRM. Yeah, I'm not going to go as far as to say yes that it will be defeated, but I am thinking, well, actually, these are very good arguments. The claims do not arise from any California activities by Miss Swift or TASRM. On the second prong of the specific jurisdiction analysis, plaintiff must show each claim arises out of or relates to the defendant's forum-related conduct. A direct nexus between forum contacts and alleged injury is required. If absent, specific jurisdiction fails. The Ninth Circuit applies a but-for test. Would plaintiff have suffered the alleged injury but for defendant's California conduct? Here, Miss Swift's and TASRM's activities lack any California connection to plaintiff's claims requiring dismissal. Yamashita and Cole Palmer are instructive despite foreign product sales. Jurisdiction was rejected because plaintiffs could not tie their injury to those contacts. The same defect exists here. Plaintiff is a Nevada resident with no meaningful California connection and nothing to show that her alleged injury arises from conduct occurring in or directed to California. She does not allege she performed or sold goods in California, and her alleged online content was available nationwide. Now, again, this may or may not hold sway. Blake Lively was not harmed in California, but she sued under California law anyway. And she wasn't dismissed on jurisdiction grounds. Okay. Nor does she allege facts supporting that the purported infringement or resultant harm is tied to California-specific activity. Miss Swift, filming a music video or attending an award show does not give rise to plaintiff's claims. She alleges no California consumer confusion from those activities, nor could she, as Miss Swift was exercising her First Amendment rights. Likewise, as in Cole Palmer, plaintiff fails to provide any factual support for the notion that Miss Swift or TASRM individually sold the album or promotional merchandise in California. Purported licensing activity with a California entity is insufficient. This is especially so where the bulk of actions taken by those entities occurred outside of California. As in Yamashita and Cole Palmer, plaintiff identifies generalized assumed forum contacts, but fails to connect them to her claims. The second prong is not satisfied and specific jurisdiction cannot be established. Exercising jurisdiction is unreasonable. Even if plaintiff could satisfy the first two prongs, she cannot. Jurisdiction would be unreasonable. The reasonableness factors purposeful interjection, burden on defendant, conflict with defendant state sovereignty, forum state interest, judicial efficiency, plaintiff's interest in convenient relief and alternative forums all weigh against jurisdiction. Miss Swift and TASRM's purported activities are nationwide, lacking any California nexus. Right. Requiring Tennessee domiciliaries to defend in California would be burdensome and implicate Tennessee's interest in adjudicating its citizens' rights, especially where plaintiff is not a California resident and has no operative facts tied to California. This district offers no efficiency advantage. it had the second highest caseload of any court in the country in 2025. And adequate alternative forums exist, including Tennessee, where Ms. Swift and TASRM are domiciled. Plaintiff does not plausibly allege that Ms. Swift or TASRM have purposefully directed any activities toward California, let alone related to her claims, and it would be otherwise unreasonable to require Ms. Swift or TASRM to defend themselves in this district. Personal jurisdiction is lacking, and they should be dismissed accordingly. For the foregoing reasons, the court should grant defendant's motion and dismiss the amended complaint with prejudice. Okay, so that was filed on the 30th of June. So that's the motion to dismiss the now amended complaint. The next video I will do will be on the order, basically, on both the original motion to dismiss and the preliminary injunction.